Court, all rise. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston and before the Commonwealth. Draw near, give your attendance, and you shall be heard. Now, State of the Commonwealth of Massachusetts, court is open. Please be seated.
Good morning, everyone, and welcome to the December 6th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and to my right, your left, is Justice Hand, and to my left and your right is Justice Walsh, and we will be your panel for today. The usual rules apply. Each side has 15 minutes. You can assume that we are well-versed with your briefs, and you can get to the heart of your case. There will be no rebuttal. We will not have a morning break this morning. We are down 2 cases, so we're going to hear all 4 cases in order, one of which is impounded, and when the time comes, everyone will remember not to use real names. With that, I think that we can call our first case, which is 21P0918, Commonwealth versus Corey Hutchins. Is it Attorney O'Reilly?
Yes.
You may begin.
Good morning, Your Honors. Ann O'Reilly for the defendant, Corey Hutchins. The defendant, at issue here, the defendant's guilty pleaded 20 counts, most of which were firearms convictions. The first issue I'd like to address is that the prosecutor at the guilty plea colloquy did not present a sufficient factual basis to establish, as required by Massachusetts Rule of Criminal Procedure 12. Rule 12 imposes a separate and independent duty on the judge to determine that a sufficient factual basis exists for a charge, apart from the question of whether the defendant's waiver is knowing, voluntary, and intelligent. A plea does not relieve the Commonwealth of its burden of proof. If there is no factual basis for the crime charged, there can be no valid plea, which the SJC found in Commonwealth versus Loring.
Could I ask one question? With respect to the, if I'm remembering correctly, the defendant is said to have made an admission before the plea colloquy, but that I think might have been in the police report. Is that correct?
In a plea, yes, he was questioned by the police.
And to what did he admit in that police report?
Well, I think the issue is here just the guilty plea colloquy, because whether he admitted to anything or not previous to the colloquy, Rule 12 is regarding the colloquy, excuse me, pardon me. So it's not as if it were a trial where this possibly could be brought into evidence. There has to be established at the guilty plea colloquy that the prosecutor has to establish a sufficient factual basis. It's not beyond a reasonable doubt, but the prosecutor has to present sufficient facts that the defendant knows that he is pleading guilty to these charges.
And I understand your point on that. Just so to fill in the background for myself, though, was the police report before the judge at the colloquy, do you know?
I'm sorry?
Was the police report available to the judge at the time the colloquy was conducted?
I imagine it might have been. But again, this Rule 12 really regards, the responsibilities of the prosecutor. And here, there were so many charges. It's not like there were 2 or 3 charges. There were 20 charges. There were many charges. So at the colloquy, the prosecutor did not present sufficient factual basis that the feeding devices met the legal definition of large capacity under Cassidy. But even if Cassidy did not apply, and I argue that it does apply because it's the interpretation of a statute, Cassidy came after this guilty plea. This guilty plea was in 2016. Cassidy was in 2018. But because Cassidy was an interpretation of a statute as opposed to a new rule, I would argue that it did apply. and that the prosecutor would have to establish that the feeding devices met the legal definition of large capacity, or under Cassidy, that the feeding devices, the defendant knew that the feeding devices met the legal definition of large capacity, meaning they could hold over 10 rounds, or that the feeding devices were capable of holding more than 10 rounds of ammunition. So there were 4 indictments regarding large capacity, and I would argue that there was no sufficient factual basis for any of those at the guilty plea colloquy.
What do you say to your brother's argument that the judge could infer, based on factors including the admission to large, high-capacity magazines and the defendant's alleged role in selling firearms illegally, that he had the requisite knowledge?
I would argue that the judge could not infer. The sufficient factual basis has to be established at the colloquy, and anything that's not at the colloquy cannot be inferred. The SJC found in Commonwealth versus Loring, the defendant admitted during his plea hearing that he didn't register as a sex offender in his birth month, and he was found guilty of that, but then the statute did not require him to do so. So then he could not be convicted of the offense of failure to register.
But the question is, and we appreciate your reliance on the case, if I could follow up to Justice Hand's question, if he admitted to the possession of a high-capacity feeding device, and that was presented at the colloquy, was the judge permitted, would the inference be permitted that he had knowledge that it was a high-capacity firearm?
The prosecutor has to establish that either the defendant knew that the feeding devices met the legal definition of large capacity, or they were capable of holding more than 10 rounds. So regarding what happened previous to this, any of the defendant's admissions, the defendant wouldn't know Massachusetts law, and I would argue, even if he did, even that no matter what happened at the interview, and he did admit, but he does not even we can't impute any knowledge of him of Massachusetts law. So it's not so difficult for a prosecutor to lay out a sufficient factual basis at a guilty plea colloquy. And here there are many issues with the case. None of the indictments, there were many firearms at issue, there was ammunition at issue, and none of the indictments referenced specific firearms or specific ammunition. It was 20 counts. Nothing was specific. And that just shows really a lack of diligence on the prosecutor's part. And he continued this into the guilty plea colloquy. Rule 12 governs what happens at the guilty plea colloquy. It doesn't govern really what happened before the guilty plea colloquy. And in Commonwealth versus Del Verde, the SJC found that a defendant's choice to plead guilty will not alone support the conviction. The defendant's guilt must, in fact, be established. So what I would argue under Del Verde that the defendant's guilt was not established because actually there were 2 issues. There were 2 elements of large capacity, Chapter 269, Section 10M. There was no information, no sufficient factual basis that the firearms met the legal definition of a large capacity feeding device, or that the defendant knew that they met the definition under Cassidy, or that they actually met the definition. So there were 4 requirements under 269 Section 10M, and 2 of them were not established at the colloquy.
And are you relying with respect to this argument on the judge's obligation to satisfy him or herself of the sufficiency of the proffer or on the defendant's knowledge, just to clarify?
Whose obligation is it? Is that what you're asking?
I know that yes, whose obligation is it? Are you saying that that it was the judge's obligation to satisfy him or herself that there was an adequate basis and that was not satisfied? Or are you saying that the prosecutor's proffer was insufficient to place the defendant on notice, or both?
Well, I believe they're basically the same in this instance. The court...
They may or may not be, so that's why I'm not sure, and
Okay,
that's why I'm asking you the question.
In terms of Rule 12, it really falls in the judge's hands to make sure that sufficient factual basis has been established.
So if the judge had the police report, would that also form the basis the judge's basis of knowledge?
The police report is not included in evidence at the colloquy.
All right,
So-
that was the previous question that was asked, and you said you weren't sure.
Oh, I'm sorry. I misspoke.
Okay.
No, the police report was not entered into evidence at the guilty plea colloquy. The
Okay.
prosecutor laid out laid out the facts.
But that isn't what the case law requires, correct? It's that the judge has available to him or to her at the time of the plea. So if the judge took the file while the plea was occurring and had the police report right before him or her, it isn't a requirement, wouldn't you agree, that it doesn't have to be admitted into evidence? This is a plea colloquy, and that's what the case law...
I'm not arguing. What my argument is, under Rule 12 and the SJC have found, and this is from Foster, Commonwealth versus Foster, it is well established, in quotes, due process requires that a guilty plea should not be accepted, and if accepted, must later be set aside unless the contemporaneous record contains an affirmative showing that the defendant's plea was intelligently and voluntarily made. So I would argue that.
So that's a different argument, I would suggest, than insufficient facts to support the acceptance of a plea. Right?
Well, there's Rule 5 and then there's Rule 12. So my argument is the contemporaneous record. What did the contemporaneous record establish in this instance? And it did not establish, of the 4 elements of large capacity, it did not establish a number 2, or number 4.
I guess, what is your contemporaneous record that you're referring to?
The colloquy, pardon me, the transcript
Of the colloquy?
of the colloquy.
Okay, thank you.
And is there any indication anywhere in the record whether or not the judge had the case filed before him or her?
Whether he had the case filed before him? Rule 12 really,
I'm not asking about the rule, I'm just asking about the record. Do we know from the record?
I'm saying it's possibly true, but that it would be,
But you're saying we don't know?
I don't know.
Okay, fine.
So, and also regarding that, factual basis, I would also argue that the charges 18 through 20 for receipt of stolen property must be vacated because also there was no sufficient factual basis for them. And those were charges regarding stolen property. And the prosecutor did not establish which of the firearms had been reported stolen, as stolen, or the defendant knew that the property had been stolen, nor was there any recitation that they were worth over $250, which is required by the statute. And the defendant, in essence, pleaded guilty to a crime it was not established that he committed.
Without disagreeing that the colloquy could, or the recitation of facts could have been more explicit with respect both to the value of the individual firearms at issue and the theft, based on the fact that the arms were being sold illegally, that there was a report that at least one of the firearms had been stolen, and there was a cumulative value for 3 guns, which at least my math would suggest would make it difficult for any one of them to be less than $250 on any reasoned basis from the colloquy. Could the judge not infer both the stolen and the value? And along with the admission that the defendant makes, is that not sufficient for a knowing and intelligent?
I would argue it's not, because it's not really what, the judge isn't the one who's pleading guilty, the defendant is the one, obviously, who's pleading guilty. So, you know, a sufficient factual basis so the defendant can hear what he is being charged with. And so, again, there was very little specificity in this colloquy. There was very little specificity in the indictments. There were many firearms at issue. None of them was referenced specifically on the indictment, so he didn't get noticed in that way. And so, you know, he's pleading to all these charges, so he doesn't have a specific understanding of what he's pleading guilty to. And that goes into the ineffective assistance counsel argument that I made as well, because the trial counsel only received, and I established in the motion for new trial record, 2 pages of the ballistics certificate. It was a 4-page ballistics certificate, so it took me a while.
Is that part of your appellate briefing, the ballistics certificate?
I believe it is, yes.
Okay.
And it's part of the motion for new trial. In the appendix, I have that, you know, trial counsel really did only receive 2 pages, and I did question him about it. And, you know, I was in contact with him, and then he just dropped contact with me, so he...
Well, your red light is blinking.
Okay. Well, thank you, Your Honors. Regarding the other issues, I will rest on my brief, and I thank you very much.
Good morning. May it please the Court. Assistant District Attorney Lee Baker for the Commonwealth. I'd like to begin just briefly talking about the issue of Rule 12 and what the standard is here for the factual basis. In our original brief, the defendant took the position essentially that the elements hadn't been proven beyond a reasonable doubt. And in my brief, I had pointed out that the standard is actually whether the evidence presented by the prosecutor plus any information the plea judge obtained in the plea hearing is sufficient when considered with reasonable inferences that may be drawn therefrom to support the charge to which the defendant is offering a plea of guilty. Now, the way I understood the distinction that my sister was trying to make with regard to Rule 12, the specific language of Rule 12 says that the judge must be satisfied that there's a factual basis. That I don't think is a live issue here for 2 reasons. One, we have the transcript of the plea in which the plea judge does on the record say that he finds there is a sufficient factual basis. So for the requirement under Rule 12 that the judge subjectively be satisfied, that was averred to on the record. And then again, of course, it was that same plea judge that heard the motion to withdraw the plea. And so I would imagine that if he had not been satisfied in the first round, that the motion for a new trial may have made him think again, and he did not.
Well, if saying I'm satisfied is enough, maybe we can just dispense with appellate review. Doesn't there have to be some objective basis that the judge should have been satisfied?
Absolutely, absolutely. And so that factual basis has to come from the information that's given to the judge at the plea colloquy, along with the inferences drawn from those facts. So it's not the case that the judge can't go beyond just adding up the facts arithmetically and coming to a sufficient number of facts. They can look at the totality of the circumstances, look at all the facts that are presented to them, along with the admission being made by the defendant there at the plea in order to determine whether or not there are sufficient facts. And here, I think there are. I think it's important to recognize, first of all, that this is a gun trafficking case, and there were over 20 counts here. There were many, many weapons seized, and a reasonable inference from that is that this is not some person who happened to acquire a firearm and then turns around and sells it illegally. This is someone who is in the business of acquiring firearms and then reselling them on the black market. I would suggest that it's reasonable to infer from the fact that this defendant was admitting to essentially being a weapons trafficker, that they would have some degree of sophistication beyond what the average person on the street would have. And certainly, it stands to reason that a large capacity feeding device would be more valuable than a smaller capacity feeding device.
Can I interrupt, though, for a moment?
Certainly.
Because if I'm following your line of argument and analysis, we should factor in kind of the expertise, if you will, of the defendant. But let's just say in a case of assault and battery with a dangerous weapon, the prosecutor fails to put in the evidence of a dangerous weapon. The defendant knows darn well that he used a hammer to do the... Later on, wouldn't that qualify if there's no evidence of a dangerous weapon and the judge said, I find that there's a sufficient factual basis for a charge of assault and battery? Whether the defendant himself knows the elements,
right,
or that the hammer was a dangerous weapon in my hypothetical, doesn't really matter, does it?
Well, I think it's a little different here, because when we're speaking about dangerous weapons per se versus dangerous as used, right? There requires some law knowledge in order to be able to make those kinds of distinctions. But I would suggest that someone, because let's look at Cassidy, right? In Cassidy, there was no direct evidence that Cassidy had knowledge that it was large capacity. And that's at trial, and where the Commonwealth's burden is beyond a reasonable doubt. And what the court found was that it was a reasonable inference that he had that knowledge. And the factors that the court looked at were the number of guns he had, the frequency with which he went to the gun range. All those things suggested to the court that that individual, that person, having that kind of familiarity with guns would therefore know whether or not they were large capacity or not. And I'm making here a similar kind of argument. We don't have evidence that the defendant was going to the gun range or was a gun collector like the defendant in Cassidy, but we have a similar set of circumstances where we know that this individual is involved in the sale of multiple firearms on multiple occasions. And I would suggest on this standard, which again I would stress, it's not even just that the standard is less than beyond a reasonable doubt. The case law says the standard is less than the Lattimore standard. So we're talking about, would this be enough information, what was presented at the plea colloquy, for it to get to a jury, at trial? And if you say no, it's not, it may still be enough for this standard. It's quite a low standard. So I would suggest that all of those factors together would be enough. And if the court doesn't have any other questions.
I actually do.
Sure.
That's okay. So let me give you, on the receiving stolen property, would you agree that the evidence of the value, other than inference?
Right.
So let me give you a hypothetical. The receiving stolen property is 3 baseball cards.
Okay.
One of them's worth $1,000.
Mm-hmm.
The other 2 are worth $100 each.
Right.
Because some of them are more valuable depending on who the baseball player is.
Certainly.
how am I to infer, just like the guns, that one of the guns isn't worth, not how am I, but how are we to interpret that the 3 guns were sold for $19.50, that some of them might have been a $50 sale, and one of them might have been a $1,700 sale? I know it's reasonable inferences, but that seems reasonable to me with guns, that their value are kind of like baseball cards. Depends what you got.
I do, that's a very interesting hypothetical. I do think that there's an important disanalogy here. And that is that you're saying, here's 3 baseball cards, right? And one's worth $100 and the other 2 are worth, say, 50 cents, right? Because one's of a, is a valuable old baseball card, another one's just a newly printed one. I think that gets to what the difference is here. If it had been the case, they'd been selling a variety of firearms that included like old Civil War muskets and things like that, then clearly there would be big distinctions between the stock that he had. But this is not comparable to a baseball card collector going and selling his collection. This is comparable to the guy at the corner store who sells baseball cards, selling his stock out of the store. They're essentially, I'm not going to go so far as to say they're fungible, but I would suggest that they are so similar and so close in time in terms of when they were produced and all of that, that their value would reasonably be in the ballpark, each with the other. And so, while it is, I would admit, razor thin, the factual basis here, I think we just get there.
Thank you.
Do you wish to address the lesser included argument?
What was the lesser included argument?
Never mind.
There was a question about the ineffective claim with the large capacity.
Yes.
I was sort of a little off because, he was charged with large capacity feeding devices.
And a large capacity firearm. And the feeding device is, at least as I read the defendant's brief, in the firearm.
No, pardon me. He was indicted, I don't have right off the top of my head, there were a lot of indictments,
Okay.
but with each and every one of those indictments, they are specific as to whether or not it is a large capacity feeding device or a large capacity weapon.
Right.
And the statute makes a clear distinction between those 2 things. So, if he's charged with a large capacity feeding device for the device that's attached to the firearm, right? It's not duplicative because you can actually charge for the firearm itself and the large capacity feeding device.
That's the argument you made in your brief under Section M. I'm also wondering whether we should take into consideration the definition of large capacity firearm in Chapter 140, Section 121. The first subsection of which is a semi-automatic with a fixed large capacity feeding device, and the second subsection says that is semi-automatic and capable of accepting, or readily modifiable to accept any detachable large capacity feeding device. Should we be also looking to that definition to separate out under subsection M the legislature's intent to charge, to render unlawful both the possession of the weapon and the possession of the large capacity feeding device?
I don't think that's necessary here because I do believe that the indictments are quite explicit.
I know the indictments are explicit. I think what's being raised here is a question of law, and I recognize that we do have a case that deals with subsection M, but in that case, and I went back and checked the briefs and checked the record, the feeding device was not on the gun.
Right. And I think that the claim being made here is that the charges were duplicative because he was charged for the same weapon when he was charged for the large capacity feeding device. And I'm saying that simply is not the case, that all of the feeding devices and all the firearms are separately indicted and
I
specific.
understand that they're separately indicted. The question is, can they be separately indicted when they're all in one weapon?
Oh, absolutely.
And I know that's your argument under subsection M, but in the case that we heard and
Yeah.
decided that in,
Yes.
they were not part of the same weapon.
Right.
I would anticipate I might hear the argument, well, we don't look at the facts under Vic. We just look at the statute. And so if we just look at the statute, I was wondering if the definition of large capacity weapon, which defines it as something that has the capacity to take a feeding device but doesn't necessarily have one, assists you in your argument, or whether you think we should ignore that.
I really don't, honestly, I'm not sure I follow.
Okay, fair enough. It's tough at oral argument when somebody springs a statutory definition on you that you hadn't thought about. But if defense counsel hadn't run out of time, I would have asked her the same question. Thank you.
Thank you.
You just let people clear the tables and all right. Our next case is 22P 0440 Commonwealth versus Hem. Is it Attorney Pickett?
Yes, good morning, Your Honor. It's Karen Pickett for the appellant, TIMMY HEM. As Your Honors know, I've raised 3 issues in my appellate brief. 2 of them have to do with the admission of evidence, the 911 tape and the knives, and the other one, which wasn't preserved, has to do with whether there was sufficient evidence of involuntary intoxication such that the judge should have instructed the jury that Mr. Hem couldn't form the capacity to commit the crime. I'll be brief, Your Honors, because I think I've laid it out in my brief, as has the prosecutors. But I do want to say I'm not challenging that the victim could testify, listen to the tape and testify, that's me. It's clearly an excited utterance. But what I'm saying is that the evidence itself is the 911 tape. And so the prosecutor, in my view, in order to admit the tape itself, needed a witness to say, either I took this call, or someone to say, I can identify my colleague who took this call. But as it stands, the tape itself wasn't authenticated. There was no foundation laid for the tape. And as we know, the victim here couldn't positively identify her assailant. I think she said, I can't, I think so, but I'm not sure, something to that effect. And so to the extent that the Commonwealth argues this is an excited utterance and it's not a confrontation issue, I totally agree. It is, to me, a foundational issue, and it's probably the most important piece of evidence in the case. I do understand that that the defendant challenged the admission of the tape on different grounds. So I assume that it would be under substantial risk standard, but still, given that he did raise that it shouldn't come in at all, that there was no foundation laid, I believe the judge shouldn't have allowed the 911 tape to come in. It wasn't a case where it came in through the victim, and then later on the police dispatcher testified to it. On the knives...
Does your argument mean that the dispatcher or someone from the department always has to testify?
I believe it does, Your Honor, because I think a tape is different than, for example, a photograph. You can show a person a photograph and they can say, yes, this is the scene at the time. It's a moment in time that a juror can understand. A tape is a little bit more complicated, and for example, the defendant might have said, well, wait a minute, were there gaps in this tape? Or
it could have challenged, I guess, the police dispatcher about how the tape was taken, the circumstances, et cetera. So I do believe either the police dispatcher or somebody who's familiar with the police dispatcher's voice needs to testify. I don't know that there's been any cases specifically on that, but based on my understanding of the Sixth Amendment and authentication, I believe that to be the case.
You're not claiming that the tape was manufactured?
No, I'm not claiming it's manufactured.
Or compromised or corrupted?
I'm sorry, or corrupted?
Compromised or corrupted?
I don't believe so, but I still think the defendant has a right to ask questions about the tape itself, and it sounds like in any event the tape was very sort of, I think it was hard to understand, and so maybe the police dispatcher could have given some information about that, and maybe when the jury heard it, they understood one thing, whereas if the dispatcher had come in and the defendant had challenged what was said, just those sort of things that would be important for a defendant to challenge. In terms of the knives, that was raised squarely. And again, the Commonwealth argues that chain of custody goes to weight, not to admission, and I agree with that. But the issue again is who laid the foundation? Who authenticates? The prosecutor comes in and shows the alleged victim these knives, and she says those were the ones that were used against me. But it's evidence. Those knives were admitted into evidence. And so again, at some point, there needs to be someone who said, we took these knives, or these are the same knives that were used. And we know that the officer who testified had nothing to do with the confiscation of the knives. And again, I'm not saying it's wrong for the victim to testify, these are the knives, which is very compelling evidence, but I'm arguing that they shouldn't have been admitted in the first place because there wasn't that foundation, wasn't that authentication, and again, not the ability of Mr. Hem to challenge what happened. I know that according to at least the motion that the trial counsel filed, the officers who were involved were suspended for some kind of misconduct, weren't available to testify. And I'm not suggesting it was because they tampered with evidence. I don't know. But again, I think somebody needs to testify about what happened. These are the knives that were taken from the scene. And again, not going to the weight of the evidence, but to the ultimate
why?
admissibility.
What does that get you that her identification doesn't get you? Your client?
Well, I think there's something to be said for because it authenticates, I guess, in a way that shouldn't have been done. Because you could challenge the victim and say, well, these weren't really the knives, or you brought these knives today. I realize it's a little bit far-fetched, but it's fodder for cross-examination. And I still think if you admit something into evidence, such as the dangerous weapon in a dangerous weapon case, that it needs to be authenticated and a foundation needs to be laid. Moving to the involuntary intoxication issue, again, I agree with the Commonwealth that on an issue of voluntary intoxication, the Supreme Court has said for a general, Supreme Judicial Court, has said for a general intent crime such as this, voluntary intoxication isn't a defense. And in this case, the defense counsel didn't raise involuntary intoxication as a defense. And I understand from a trial judge's perspective, it's difficult for a trial judge to sua sponte give an instruction on involuntary intoxication when it wasn't raised by the defense. So I do understand that we're under a substantial risk standard here. But I would suggest that really this was kind of the only defense, viable defense, because the victim herself didn't want to press charges, and not because she had a close relationship with Mr. Hem, but because she said over and over and over again, he wasn't himself, he wasn't acting like himself, it was the drug, he has serious mental health issues, he was calling for an ambulance. So I think that there was sufficient evidence there to put the burden on the Commonwealth to show that it wasn't involuntary intoxication. To me, it sounds like maybe he took some kind of psychiatric med and went haywire. I don't know what he took, obviously. And
so if I understand your argument, the evidence isn't necessarily of involuntary intoxication. It's the effect of whatever he took in combination, perhaps with other substances, that he didn't expect, I guess.
Right. You can voluntarily ingest something and have involuntary effects. I think the cases say, for example, if you're drinking, which is voluntary, and you take your prescription meds and you have this, you have this off-the-wall reaction where you do something that you're sort of out of control, then that would still be within the realm of involuntary intoxication. Again, I realize it wasn't raised below, and I always feel like it's difficult for a judge to raise something like that sua sponte, but again, this is a case where the evidence was strong that the defendant was pretty much out of his mind. So if the court has no further questions. Thank you, Your Honor. Just as an aside, I was talking with ADA Steinfeld, and we were both saying how impressive it is to have a three-woman judge panel. When I clerked here 25 years ago, there were 3 women judges total. So kudos. Thank you.
Every once in a while it happens.
Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. I just want to point out as to the last issue, that the only evidence that the defendant had ingested anything was the victim's statement that he seemed to be under the influence of something, had a reaction to a drug, and it was the drug that was doing it. That's it. And that's not even close to showing intoxication, much less debilitating intoxication. I don't have anything else to add to what has already been said or what's in my brief. I'd be more than happy to answer any questions the panel has. Otherwise, I would rest on my brief.
Thank you very much.
Thank you.
All right. Our next case is 22P0078, Department of Children and Families, and a mother versus mother and father. I'll remind the parties that this is an impounded case. We'll not be using proper names, and I gather both sides will be splitting their time. Attorney Yanoff?
Yes. Morning, Your Honors. My name is Warren Yanoff, and I represent the mother in this case. These cases are difficult and troublesome always, but when you look at the totality of these circumstances, this case merits a remand and a finding in the sense that DCF did not do what it should have done and needed to do, as well as the fact that in this case found that the mother was unfit, but the mother doesn't have that burden. DCF has that burden. The issues that the judge used really were not dispositive of her unfitness. Yes, the mother and father argued, but that was not in the presence of this particular child. There's no nexus to that. They had worked things out, and they were separated at the time. Secondly, her criminal history was misused because those cases were dismissed. She didn't have a criminal history, notwithstanding certain arrests and things like that.
So I think that constitutes a kind of a debate about what criminal history means. Let's take the label off it. Could the judge consider the fact that she had been charged with various offenses which were then continued without a finding?
I think if you're going to use that, I think you then have to know more about the intended circumstances, not just to look at a Carey report that says she had been arrested. It would be certainly the department, if they wanted to use the criminal history, to expand upon what the facts were or why it happened or whatever,
So
giving...
Could the judge have considered police reports as she did with respect to the DV issue?
I mean, again, I think police reports You need to have the police officer testify. The report itself, I think, shouldn't be dispositive of the conduct.
But doesn't adoption of Luke say that the evidence goes in and then it's up to the parent to challenge it?
But if you think about it, that's sort of backwards when the burden is always on the department to show.
I understand that there's an anomaly there.
But,
Please proceed.
the issue really is that, again, the judge said she didn't have housing. She was not homeless by definition, and even if she were, homelessness is not a basis for unfitness. But she was living with the mother. She had previously taken care of this child. This was not, yes, she had a substance abuse issue. Yes, she was in treatment. And when we talk about terminating a parent's rights, we're talking about current unfitness, not past unfitness. At the time of trial, she was doing what she needed to do. But the real, I'll say, issue in this case, and what's really inordinately problematic, and I've been doing this far too many years, to see a foster parent hire an private investigator following mother and father and social workers, where in order to get the child back, had to sign a statement that they weren't going to do this. They did everything to make sure mother was never going to have that child. They told the child not to call my client mother, except for the first.
Do we have evidence of that, or is that an
It's
inference?
it's in the reports of the social worker testified to that. And when you have a child in the investigator saying, I'm supposed to tell the investigator, mother did this and mother did that. Given that child's age, if that's not coaching, I don't know what else to say. This has been truly, when we look at these cases, it is two-pronged. First prong is unfitness, and I think that failed. But most importantly, we're talking about best interest. When we sanction conduct, when the department says, well, we're going to place it with the foster parents, but the foster parents are doing everything that they're not supposed to do. They're supposed to encourage reunification. When we allow that to continue, the whole system breaks down. Process is as important as results. We don't want to go in that the ends justify the means. These foster parents were totally set in wanting to have custody and maintain this child and make sure that there's no relationship between mother and child. And we have a frail woman who has some issues and didn't have the stamina to go to the department. The department sets all these situations. But
Counsel, can I interrupt you just before you move on to
Sure.
another topic and ask this? What is the most recent incident with respect to the trial of the foster parents coaching or, in your view, improperly impeding
I
the
think
child's
that's
union with the parents?
In the court investigators, I believe it's the court investigators report, it was the testimony, I believe, of the therapist.
But how far back?
It was not that far, it was right before trial, as I understand it.
And was that addressed in any way as far as a don't do that again in the same way that the issue of the investigator was?
I think so. I mean, let's put it this way. I think it was condoned in the sense that they didn't remove this child. The foster parents had this child. Mother and father had the child, and then they replaced it. They should never have put the child back into with these, given the history. And that's what's really very upsetting. Once that happens, mother becomes distraught. She knows she's got more than an uphill battle. She has the department, in a sense, already with a goal not to reunify, but you have foster parents who are doing everything and coaching this child.
Leaving aside, because your time is waning and I'm going to run you over a little bit, but leaving aside the foster parents for a moment, and I know that the father is also going to address that. Let's say we take criminality out of it. Let's say we take the housing stability out of it. Let's say we take out all the things that you briefed. As I read the record, this is a mom who, regrettably and with sympathy, has had substance abuse problems since the age of 18. 3 out of 4 children over a 7-year period were born with substance abuse exposure, and who at one point during these proceedings said that she thought it was better that she not see the child because it was very difficult for her and she had things she needed to work out. I'm paraphrasing, but the quotes are in.
Understood.
Why would it be impermissible for the judge, with all sympathy for the mom, to look at that constellation of events and say, mom's doing her best, but it's not enough, and this child, with all the special needs this child has, needs stability?
Well, because I think what we're looking at the time of trial, she was actively engaged in something. She had been appropriately parenting this child for a reasonable period of time. The issue really has to do with what does current fitness or current unfitness mean, and to the extent that it's more, I would say, Carlos, and I don't think everything is intertwined, and I guess when because of the foster parents, I don't want to say because of the way this case evolved, she was so disturbed with that placement and all those obstacles and being called by her first name instead of by calling mama, with her weaknesses, that I think that in any event, the child should not be placed for adoption with these foster people because they did that, and I appreciate the extra time.
Good morning, Your Honors. Tamika O'Brien on behalf of the father. Your Honor, father does not concede unfitness in this case. We're not here for that today. However,
Do or do not concede?
he does. I'm sorry, he does.
Thank you.
We do not argue that he was fit. However, and my brother spoke this at length about the foster parents. In this situation, the foster parents undermined DCF's and mothers and fathers' efforts at reunification here. It is absolutely a requirement of foster parents under the DCF regulations 110 CMR 7.1041H that they that the foster parents facilitate visits. And in this situation, the foster parents did not do that. They did the exact opposite. They hired a private investigator who filmed the DCF worker and father in this case. And instead of helping with the transitions, as they are required to do under DCF regulations, and this is really also on, the foster parents here were at fault, but they were allowed to do this by DCF. And that is a burden that DCF should have been taken to task for and wasn't. But instead of helping this child with these difficult transitions, at the time the child was 3, he's crying, and instead of helping that child through that, they stood back and let our investigator film what was going on. Your Honors, termination is not just an unfitness issue. It also has to be in the child's best interest. And if you look at this case, the child's best interests were not served by these foster parents. We're not talking just about the filming. We're not talking about hiring the private investigator. the foster mother unilaterally and without discussing with DCF removed the child from therapy in 2020. This is a child who had a lot of trauma. No one disputes the trauma. Had a lot of issues, social, emotional issues, and there was a lot going on in this child's life that he needed that therapy. Now, the department argues, well, it was, COVID. And I get that. It was a strange time, very difficult time. But it left this child without that therapeutic support that he so desperately needed so that this family could at least attempt to stay together. Your Honor, something else I think is really important is the judge found, based on the expert, that the child was not coached about trauma. And I don't disagree with that. It doesn't seem that the child was coached about the trauma. No one disputes the child was traumatized. But the question here is really whether or not the child was coached about mother and father and visits. And the trial judge in this case made no findings on that. To answer, I believe it was your question, Justice Sullivan, about the last thing in the record that shows that the foster parents weren't I'm trying to find the right word, were working against the department and against the parents. And I want to bring it back to that therapy here. Finding of fact 146 shows that in 2020, which was a year before trial, that the child had been pulled out of therapy. He didn't get back into therapy until July. It took him months before he was able to be productive in therapy again. And I think that when you're looking at a 3-year-old child with these kind of issues, and at that time I guess the child was probably 4, with these kind of issues, who is in a foster home where he is no longer calling, he calls the foster parents mother and father and no longer calls his parents that, when he's telling
The judge make findings as to how that came to be,
is how the
name switch of who was mommy and daddy.
not that I am aware, and it does happen in a lot of these cases where, the child bonds with the foster parents and then they refer to them as mom and dad, mommy and daddy, and understandably, the biological parents are very upset about this. But I think that what's, really notable here is it wasn't just that he was calling mom by her name but he was saying, you're not my parents, you're not my real parents, you stole me, put that in your report. What kind of 4-year-old child says this kind of stuff? And there was clearly coaching going on here, but the judge made no findings. The trial judge in this case minimized the pre-adoptive, the foster parents' behavior, and made very few findings, but basically said, well, sure, it was not appropriate that the foster parents hired a private investigator to film the social worker, but the department knew about it. And the department resolved this issue by having the foster parents sign an affidavit. I can only imagine if that were the parents who had hired a private investigator and had filmed the department, how that would have gone over.
Let's assume, for purposes of argument, that we were to agree with you that the foster parents behaved inappropriately. Let's assume, for purposes of argument, that the judge made a finding that they coached the child to call them mommy and daddy and to call mom and dad by their first names.
Sure.
But you have a finding of unfitness, and this is the only home this child has ever known. Are we able to say that the department has not shown by clear and convincing evidence that this placement by adoption, and if that is our standard, and that's actually a subsidiary question, department has to show unfitness by clear and convincing evidence. When it comes to the adoption placement, what's the standard of review, and has the department met it?
I think,
there's kind of a Hobson's choice here going on.
Sure.
There's bad facts all the way around.
Sure.
Under that hypothetical.
There are, and that's why father is not, concedes unfitness. I think early on in this case, from the beginning, the foster parents showed an unwillingness to work with the social worker in this case. They actually somehow got a new social worker, which is almost impossible to do. If a parent doesn't work well with a social worker, they're just stuck with that social worker. So from the beginning of this case, these foster parents should not have been considered as an adoptive resource. And the department had the burden of coming up with a better and more viable plan. And this, and for this reason, this was...
And they didn't.
And they didn't.
So what does the judge do with a kid who's only known that home and the mom?
Sure.
And dad. Sorry, your dad.
You know, it is a tricky situation. What does the judge do? I don't know that I have a clear answer for that, but this adoption plan was not a suitable one. It wasn't within this child's best interest, and that's really the judge's decision to make. I'm not sure that the judge should have said, you know, well, this is the only thing we've got here, so let's terminate the rights and let these foster parents adopt this child. I think that even if the adoption plan was not viable, you look at DCF and say, come up with something better.
Thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court. Monica Mleczko on behalf of the Department of Children and Families. This is the second care and protection case involving the child who is now 8 years old and who was diagnosed with post-traumatic stress disorder and anxiety during the pendency of this case. A careful review of the trial court's 164 detailed and specific findings of fact and additional conclusions of law show that the trial court paid close attention to the evidence, even-handedly assessed the good and the bad, and did not abuse its discretion or commit any clear error of law in terminating mother's parental rights and approving the adoption plan. Its conclusions are therefore owed substantial deference and should not be disturbed. I'm going to highlight the key facts that support the trial court's decisions.
You can assume that we're fairly well familiar with the key facts. What do you think the three strongest facts are for supporting the termination of the mother's parental rights?
Your Honor, I would say that the critical nexus that the court should be considering this case and reason to affirm the trial court's position or trial court's decision is largely threefold. First, the mother failed to treat both her substance abuse disorder and her mental health situation for the duration of the entire case.
Well, Mom did enter various programs. She just didn't succeed.
Correct, Your Honor, that there is a history.
She failed to treat. She failed to succeed.
She failed to consistently treat both her substance abuse disorder and her mental health issues. I will say there is a critical fact that mother testified during trial that she actually was not engaged in substance abuse treatment from November 2017 up until one of her many relapses in 2020 because she didn't feel that she needed to, which the trial court specifically noted was evidence of the mother's lack of insight into her own mental health issues. And she does have a very long history of treatment followed by relapse, which the court noted in this case. This child was born and had to spend the first 7 weeks of his life in the hospital because he was born substance abused. That led to the first care and protection petition in that case.
We're familiar with that. I asked you for what your three best facts were for current unfitness.
And, Your Honor, and in addition to the substance abuse and the regular treatment, failure at treatment, and repeated relapse, the critical facts in this case are that mother was unable to provide the child, both while he was in her custody and following when he went back into the department's custody, with a stable housing situation and consistent access to caregivers.
What assistance did the department provide her for housing?
Your Honor,
they know they're dealing with somebody who's got substance abuse issues and is somewhat unstable. What proactive efforts did the department make to assist her with housing?
Your Honor, during the current pendency, the the current care and protection case, mother was largely whereabouts unknown during almost the entire case. So the child went back into the department's custody around March 2019. And mother did have some visitation and interactions with the department up until the fall of that year. But largely starting in December 2019, they were unable to find mother and did try extensively. They weren't able to find proper phone numbers. Mother did reach out occasionally, and they didn't have an ability to visit her home. She did not make herself available. They sent her access and resources that she should be seeing, and she didn't reach back out to them. And that was largely from December 2019 up until the start of trial. And it's also important to note that during that time period, mother failed to visit the child entirely, and in fact failed to inquire at all about the child's well-being for almost that 15-month period leading up to trial. And that is a critical fact. And also while the child was actually in her custody, she failed to provide the child with a stable living situation, which is critical for all children, but in particular this child who suffered from...
I think that relates back to being unavailable to the department. There is a shared responsibility, isn't there, on housing, if she had been in touch with the department, for the department to provide some form of assistance?
To provide assistance, yes, Your Honor.
Okay. But you're saying they couldn't do that in this situation because she had gone missing?
The mother was largely in touch and unavailable to the department during almost the entirety of the current case.
Okay. Is there any other fact that you would like to stress regarding mother's unfitness?
Your Honor, so I touched on the instability of the living situation and the chaos that the child found himself in.
Let's move on from that. If nothing leaps to mind and you can return to it, can we talk about the arguments that you've heard today about the suitability of the foster home?
Yes, Your Honor. So I would like to make very clear that as I mentioned, this is the second care and protection petition, and what the trial court record supports is that the foster family did hire a private investigator in connection with the first care and protection petition. And actually, the department did have the foster parents sign an agreement that they wouldn't hire a private investigator and make sure that they participate and help with the reunification of the child with the parents, and that there is no evidence that with respect to the second care protection petition, they didn't do exactly that. To the contrary, the record shows that the foster parents did assist the child in meeting with the parents by encouraging him to get into the car. And so I think that there is a clear distinction between the first care and protection case and the second.
I think the argument is that once the department has to ask someone to sign an affidavit like that, the alarm bells should have gone off and they should have found a different placement.
Your Honor, but in this case, two additional facts. Not only were these particular problems didn't come up again in the second care and protection case, which I think is significant as to the impact that it had, but also there is no evidence that the child was removed from his parents' care because of the foster parents. The events leading up to it largely had to do with mother's substance abuse, the lack of stable housing situation that led to that second removal. It wasn't the foster parents or their hiring of a private investigator or any alleged coaching, which I can also speak to, that led to that second removal.
Do speak to the coaching issue, please.
Your Honor, in this case, there was an expert that testified at trial about many things about the child's mental health. One of the things that the expert testified to is coaching, and in particular, which the court credited, that the child was not coached. And there were
Not coached about trauma, but what about the coaching with respect to calling mom by her first name, saying you kidnapped me, calling the foster parents mommy and daddy? What is the evidence on that, and what are the judge's findings?
I don't recall a specific finding whether or not the child was coached on this fact. However, what we do know is that the expert did testify as to the child's state of mind in connection with his experience with his mother and father, as well as his foster parents. And one of the things that the expert specifically noted is typically coaching breaks down over several sessions, which is not what happened in this case. And the child
Coaching about trauma or coaching about interfering with the parental bond?
coaching. And specifically, what the expert found was that the child would speak about his experiences with mother and father as places where, as a home where he got hurt and where he repeatedly said, "I'm so scared," and among other things that are quoted more extensively in my brief. But also then contrasted with the home experience he had with the foster parents, where he was happy and everyone liked him. I'll also note that the child is now 8 years old. It was about 6 years old at the time of trial, and he had spent 15 months total in his mother's custody. And so there's a reasonable inference that having spent so long with his foster parents, that it would be more natural for the child to refer to them as mama and papa.
But we can't make that inference, right? That's for the trial judge.
That's correct, Your Honor. And so unless Your Honor has further questions on the coaching aspect, and it appears I'm out of time, largely out of time, but with that I would rest on the briefs as well as the argument in this case and ask that the court affirm the trial court's decision both with respect to parental rights as well as approving the adoption plan.
Thank you very much.
Thank you.
Good morning, Your Honors. Daniel Katz for the child. The attorneys for the parents gloss over the issues and the nexus that make the mother unfit. As Your Honor pointed out, there was a nexus between the substance abuse and her inability to give minimally acceptable care for this child. As you quite rightly said, 3 of her 4 children were born substance abuse. And even when this child was in her care, she had admitted to using drugs. And as my sister pointed out, there was a time when she said she did not believe that she needed substance abuse treatment, yet there she is using drugs. As this court is aware, you are allowed to consider the past substance abuse of the mother. It wasn't enough that she gave birth to a substance abuse child who had problems feeding and was in the hospital. Did she learn from that? No. She had another child who also had those same issues. It's clear that she did not learn that there was a connection, and it's disingenuous for the attorney for the mother to argue that there was no such connection between her substance abuse and her inability to give care. Now, in Luke...
I don't think we need to characterize it that way, and I'm not sure it's a question of learning. We're talking about substance abuse and an addiction disorder. So is it a matter of learning, or is it a matter of ability in the moment to overcome the addiction?
To overcome, and we realized, right, the court in Luke acknowledged that, yes, there might be several times when one is...
It's an illness, and we don't need to blame people for their illnesses.
Right, but if you argue... Pardon?
The question is fitness.
Question's fitness, but if you're going to argue in your brief that Catherine applies, and what we have known from Catherine, which has been a seminal case in this field of the law, that a cocaine habit in of itself is not sufficient, we certainly We absolutely do not have that here. And therefore, that's why I used that word.
Let's just talk about the legal issues in the argument.
Well, that is a legal issue, Your Honor, in terms of there was a nexus between mother's substance abuse. There was also a nexus between her inability, when the child was put back into her care, he was taken around from living situation to living situation. An expert testified, and I guess we don't really need the Supreme Judicial Court to tell us that stability is important in the children's lives. It seems quite evident, but there it is in black and white from the highest court in this Commonwealth. And here is a case where this child, an expert testified that stability was important, and yet when the child was placed back into her care, there was severe instability. Also, the mother seems to gloss over and say, oh, well, the child did not hear the domestic abuse. I would like to read, Your Honors, what happened that night when the father said that he was scared for both his safety and the children's safety, not specifically just the child of this appeal, but the other children who were at home at the time. Now, it's true, we do not have specific evidence that the child witnessed by sight, but the child was at home, and we have testimony from the father saying that not only he was scared for his own safety, but for the safety of the child. That child has been with this pre-adoptive home essentially all of his life. There was a time when there was an attempt for reunification, and yet during that time, mother was unable to provide minimally acceptable care, and even said, I don't think I need treatment. Thank you.
Thank you very much. That concludes argument in this case. The next case is 21P1144, Sarabian versus Flagship Insurance Agency, Inc. Attorney Tomlinson?
Yes. Good morning, Madam Justices. Attorney Ray Tomlinson on behalf of appellants Richard Surabian and Stephen Sarabian, two brothers doing business as Sertan Manufacturing, which is a leather wholesale goods manufacturer and retail store located in South Yarmouth on Cape Cod. Forgive me, I'm a little short on voice, so I hope you can hear me okay.
Just pull that mic a little closer and you'll be all set.
Thank you. After a bit of a tortured procedural history between this and a prior action, this case comes to you following the lower court's dismissal of a second filed action following a Rule 41 voluntary dismissal without prejudice in the prior action. In this case stems from a February 23, 2016 non-suspicious fire at the Sarabians retail store in South Yarmouth. Shortly before the 2-year limitation period expired under the applicable policy of insurance, the Sarabians brought suit against numerous tortfeasors, including an insurance agency, Flagship Insurance Agency.
But not Mr. Breton in particular?
But not Mr. Breton in particular, just the agency at that point. At that time, the Sarabians did not have sufficient facts to allege particular claims against Mr. Breton in light of the special relationship that they've had over 25 years. In response to, upon filing suit and making service upon the parties, one of the defendants, Ball and Boyd public adjusters, they were the public adjusters hired by the Sarabians, filed an answer to the complaint. They subsequently indicated and filed notice of a motion to dismiss, but the first response that Flagship I received...
Who filed the notice of the motion to dismiss? Flagship only?
Actually, motions to dismiss were brought by, were properly served by all of the defendants except for Flagship. Flagship merely indicated in a written correspondence that it would pursue a motion to dismiss and seek sanctions.
And then the Sarabians dismissed Flagship before that was filed, correct?
So yeah, so at the time the Sarabians are indigent because of the fire. They've had to move their business to a rental location. They're doing everything they can to keep their business above board after 50 plus years in business. And they just had to choose between, can we afford to respond to 3 motions to dismiss or also a 4th? And at the time, they were concerned about the strength of their case as against Flagship. They didn't quite, although they had a reasonable information and belief, they didn't quite know the extent to which Flagship was involved in the administration of their claims over the prior 2-year period. So they voluntarily dismissed Flagship without prejudice under Rule 41. Initially, what's interesting about this is initially the clerk's office at the lower court rejected the Rule 41 voluntary dismissal because of Ball and Boyd's answer. However, I then filed a subsequent Rule 41 voluntary dismissal and specifically cited to the Flynn versus Church of Scientology case, which in the appeals court said that the plaintiff's right to voluntarily dismiss prior to the answer of the adversary or filing of a summary judgment motion, or excuse me, service of a summary judgment motion, that right to voluntarily dismiss, regardless of the filing of another answer of another defendant, is absolute and unconditional, and the court doesn't have any discretion. And that's what lands us here today, because the lower court then, after the voluntary dismissal, the appellant's plaintiffs in the lower court brought a motion to amend, and the motion to amend sought to return Flagship, but also Brian Breton as an individual defendant.
Can I ask this, with respect to the motion to extend discovery, and was there also a motion to extend the tracking order?
There was.
When was that?
June of 2019. So prior to...
And I'm sorry, could I ask you one other question on that, just to keep it clear? Did the motion to extend seek specifically to extend the deadline for Rule 15 motions?
It did.
And it was not extended, correct?
The court took no action on that. The court granted the motion, but did not specifically extend the Rule 15 deadline to a date certain. So the motion to extend and retract was allowed for individualized case management, but as Judge Perino noted in his Rule 15 order denying the subsequent motion to amend, and the timeline here is important because the motion to retract came before the motion to amend. There was only one deposition that had occurred, and that was of Flagship's Mr. Breton and Maria de Sousa, an agent executive at the office.
When were the depositions taken?
November of 2019. So the motion to retract occurred before the deposition. Within a month following the deposition and receipt of the transcript, the Sarabians then immediately brought their motion to amend. The only substantive response in opposition to the motion to amend was that the voluntary dismissal under Rule 41 should have been involuntary and with prejudice. And that's the analysis that the lower court adopted in violation of longstanding precedent. And that's what brings us here today. So at that time, the Sarabians are left with the denial of a motion to amend, which is not immediately appealable, and a soon-to-expire limitations period, so they were forced to file a new action. Now, that new action that they filed was entirely proper. They could have brought that as an independent action previously. They didn't even need to pursue a motion to amend. They could have filed a separate suit against Flagship and Breton, regardless of the commonality of interest or overlap factually. They're joint tortfeasors or not joint tortfeasors. plaintiffs always had the right to bring as many causes of action and in many complaints as against as many defendants in as many actions as they chose. From an efficiency standpoint, they sought to amend in the prior action because of the overlap of the facts. And
Were they necessary parties to the first action?
I'm sorry, one more
Were they
time?
necessary parties to the first action?
I would say no, they were not necessary parties to the first action. I take that back. I think it could be argued both ways. I think that from a Rule 19 standpoint, Bryan, Breton, and Flagship are not indispensable parties to the first action. Okay? Are they conveniently before the court in that action? I would say yes, because from just a sheer duplicity of discovery standpoint, a lot of the issues and the facts are same, and they are operable fact witnesses and players. But the determination of whether or not Bryan Breton is a fiduciary or a mere broker, and whether or not Flagship was negligent in administering the claims, is not dispositive to the issue of whether or not there's coverage for the claims, which was the overall genesis and gravamen of plaintiff's complaint in the prior action. Notably, Flagship did not object to the voluntary dismissal without prejudice. They did not ask the court to convert it to an involuntary dismissal. No other party objected to the voluntary dismissal without prejudice. And all of this occurred before plaintiffs had obtained any discovery that would give rise to the claims that supported the motion to amend. And that's really the critical issue here, is that Flagship did not substantively dispute any of the facts as implausible. They simply argued that they were improbable and perjured, okay? And that goes directly to specific knowledge and intent of the parties.
Well, they also argued that the claims, if I understand correctly, that the claims as set forth didn't plausibly suggest an entitlement to relief on the Giannichino standard. It wasn't just that they were implausible in fact. Isn't that true? Correct,
but they did not substantively indicate exactly how the claims were implausible. And in fact, under the Schwartz versus Travelers case and McHugh versus Prudential cases, it is plain that plaintiffs argued a reasonable set of facts that would reasonably give rise to the relief sought, namely whether or not Bryan Breton, by inviting himself into the claims settlement and administration process, exposed himself to a modestly heightened duty of care above that of an ordinary broker. Separately, of course, Flagship is liable in negligence and for fraudulent concealment of the policy change request from August of 2015. So approximately 7 months prior to the loss, the Sarabians went to Bryan Breton and said, please, we have the wrong mortgagee listed on our policy, and we would like to add my brother's irrevocable trust as an additional insured. What actually went to the insurance company and was not seen by the Sarabians removed the mortgagee entirely and then named the irrevocable trust as the mortgagee, which was not correct. And so the plaintiffs didn't discover that until after they had already voluntarily dismissed, without prejudice, Flagship. And so it was later discovered that, in fact, the very genesis for the insurance companies claim that the policy, that they owe no duty to defend or indemnify and that the policy is void ab initio, is based almost entirely on this policy change request, where the insurance company argues, hey, the insureds committed fraud under the policy by intentionally misstating who was the mortgagee. Of course, the mortgagee was long a matter of public record and known to the insurance company for years. But that's the basis for that. And as a result, the Sarabians believed that it was best and most efficient for all of the parties to simply seek to move to amend rather than bring an entirely new action. But when the motion to amend was denied, the lower court erred because it said, and I understand.
Before us.
I'm sorry?
Is the denial of the motion to amend before us?
I'm sorry, Your Honor, I didn't hear you.
Is the denial of the motion to amend before us? That's in the underlying case, which isn't completed. There's been no appeal.
No, it is not, Your Honor, and that's an excellent point. There's no final judgment in the prior action. However, the motion to dismiss that is before you on de novo review by the lower court considered and erred, that's the basis for the appeal, is that the lower court erred when it considered that the Rule 41 dismissal and then subsequent motion to amend was a final adjudication on the merits. And
That's our focus, right?
that's our focus. The focus here, Your Honors, is whether or not the denial of a motion to amend operates as an involuntary dismissal with prejudice, such that it is preclusive to a second action. And in this case, Your Honor, that utterly, to take that position not only flies in the face of 85 years of jurisprudence, but it also offends the two-dismissal rule under Rule 41. It would render it mere surplusage and a nullity. Essentially, the two-dismissal rule is designed to protect both the plaintiffs and the defendants in the event that there is a voluntary dismissal without prejudice. You don't get more than 2 bites at the apple. If you voluntarily dismiss, you can come back one time. But if you come back that second time and you voluntarily dismiss again, Rule 41 expressly provides that unlike the first dismissal, which is without prejudice, the second dismissal is with prejudice, and therefore that would trigger a preclusive effect on a subsequent action.
But if we concluded that the dismissal were with prejudice, then the two dismissal rule wouldn't be implicated, right?
Correct. The two dismissal. If we conclude that a Rule 15 under Massachusetts state law, and that's really a critical issue here too, is that the appellees argue that essentially this court should adopt a federal precedent standard, which is that the denial of a Rule 15 motion to amend is with prejudice and preclusive. And the Commonwealth does not follow that line of jurisprudence. There is a very narrow sliver of cases in the Commonwealth. I'm running low on time, I'm just keeping a check. There's a very sliver and narrow exception to that. And if you read between the lines in the appellee's brief, you'll find that their focus and use of federal precedent is focused almost exclusively on post-judgment remedies, okay? And whether or not the Rule 15 motion came post-judgment. Was trial imminent? Was there an opportunity for discovery? Was there notice to the other side? In this case, none of those factors are in play. It was in the infancy of the earlier case. The case was tracked on a fast track as an insurance claim. It was aggressively tracked. There are many, many moving pieces to this puzzle, and simply the plaintiffs did not have the resources at that time and chose to exercise their unconditional right to voluntarily dismiss. And then the lower court simply converted that to an involuntary dismissal and said, you should have because you knew the identity of Brian Breton. Commonality of interest or identity of a party not sued is insufficient to preclude a subsequent action, because doing so would violate the rule against non-party preclusion.
So do you view this as an issue of claim preclusion or issue preclusion?
I'm attacking both, Your Honor. I would suggest
Do you think that the Jaros case, which deals with issue preclusion, has reasoning that applies to the claim preclusion arguments as well? Are you arguing that for both kinds of preclusion?
Yes, I'm arguing that short on time, I'm arguing that any preclusive import, any application of any preclusion doctrine under the facts and circumstances of this case offends due process because it puts plaintiffs out of court and denies them the resource that's available to them to pursue their claims. If you apply any kind of preclusion in this case, whether it's issue or claim, res judicata encompassing both doctrines, you either, without creating a privity exemption, and there has been no effort on the part of the appellees to carry their burden in that respect. I see them out of time. If there's any additional questions, I'm happy to answer. Otherwise, I'll stand on the papers.
All right. Thank you very much.
Thank you, Your Honors.
Good morning. May it please the Court, my name is Tim Egan, and I represent the appellees in this case. This presents an interesting issue of civil procedure, which is somewhat of an oxymoron, but it's also an open issue.
Not at all, not at all.
Which it's also an open question in Massachusetts as to what is the preclusive effect of the denial of a motion to amend. Just to give you a little bit of background, additional background, when the case was first brought in February of 2018, Flagship was originally a defendant. We notified the plaintiffs that we intend to move to dismiss and for sanctions, and they voluntarily agreed to dismiss the claim. They waited then over a year. Discovery went forward, the case went forward, and they took no action to bring Flagship or Mr. Breton back into the case. When they did ultimately move to bring them back in, we opposed that, and the court agreed with our position that they simply waited too long. They knew Mr. Breton's identity, they knew his role, it was no secret to them, but they had sat on their rights. The idea that a voluntary dismissal somehow gives a party leave to bring the party back whenever they want is incorrect. And they still had a duty to amend seasonably. They waited till after the deadline had expired and then sought to do so.
But again, that isn't really before us, right? The motion to amend, the denial of the motion to amend isn't before us. The only issue is, as you noted, is it final?
Right, and that is an open question in Massachusetts. Go ahead.
Do we all agree that we have to have a final judgment?
Yes.
For preclusive effect?
Yes.
All right.
Yes.
And finality in terms of claim preclusion or issue preclusion or both?
Both. Both.
And do you think that both claim preclusion and issue preclusion arguably apply in this case?
I think they both arguably do apply in this case.
Do you see any distinction in the analysis as between claim preclusion and issue preclusion for purposes of the arguments you've made in your brief and here today?
I do not. I do not think that there is a distinction there that matters. But when federal courts looking at this issue have determined that it does have preclusive effect, the denial of a motion to amend does constitute a final adjudication.
Is there a case in the federal list, and I apologize for not knowing the answer to this, but in the cases that you cite federally, is there one that says what you're saying now, but arose under similar circumstances as this one? And by which I mean, there was a dismissal, there was the underlying case had not gone, a failure to amend, inability to amend. The underlying case to which the amendment related had not been resolved on its own, and then there was also a simultaneous filing that, for the purposes of argument, we assume was within the statute of limitations. Is there a case that speaks to that?
Yeah, well, the case that's most directly on point and has very, very similar facts is a case decided at the appellate division, and that's the Shahidi case.
Right.
And they track the analysis, and they cite a federal case that's not on all fours, but the Shahidi case really is on all fours with the analysis and I think tracks. So that's the case that I would direct you to for the reasoning as to why it should be given preclusive effect in this case.
I was somewhat surprised to see that we have apparently adopted the federal rule that the pendency of an appeal doesn't matter, or the lack of opportunity to appeal doesn't matter. And the case is still pending in the trial court, I gather.
Yes, it is.
The underlying case. To the extent that the motion to amend didn't deal with the merits, but merely timeliness.
Right.
Does it constitute a final judgment on the merits? Do we need a final judgment that's also on the merits?
I don't believe so. Under the case law, that is considered final enough. That the dismissal of a motion, the denial of a motion to amend, that is considered final for the purpose. And if you look at the restatement of judgments, second, the section 26, I believe, they say that the failure to either seek reconsideration or appeal the denial of a motion to amend it can be fatal.
But there's been no opportunity to appeal the motion to amend at this point.
Right. Well,
right?
yeah.
So that's where we get where it gets a little circular for me, just because of the procedural posture that we find ourselves in.
Right. So
here's the anomaly I'm trying to struggle with. If no motion to amend had been filed, and they simply filed a separate lawsuit, would we be here?
Well, yeah, but what they've essentially done is done an end round. They've taken the gavel out of the trial court judge's hand, because when he denied the motion to amend, he found that it was untimely. So rather than appeal that decision or seek reconsideration.
They can't do.
Yeah, this is, friendly made that a nullity, because they filed a whole new action and then sought to.
That's not my question, though. My
Okay.
question was, if no motion to amend had been filed, but the separate lawsuit had been filed, would we be here?
Well, we would be dealing with a motion to dismiss on the substance of it rather than the procedure, because by bringing the second action, they already had a statute of limitations problem with the first case. The second case now being a year and a half later, they have a problem with statute of limitations if the case goes
Your
forward.
argument amounts to a trap for the unwary, which is that what you have to do is file the separate action and move to consolidate rather than file a motion to amend. Because if you lose the motion to amend, you're out of luck.
I think that that's true.
Okay.
So unless the court has any further questions, I think it's a fairly straightforward but interesting legal issue.
Oh, that's straightforward. But
And just to pick up, how is that fair?
How is
So if, instead of filing a motion to amend, to add the parties, in a timely manner, they file a separate action and consolidate, that's okay. But the motion to amend, which seems to be the cleaner process, is not okay.
well,
How is that fair procedurally?
Well, procedurally, it was unfair to the defendants in this case to have the case proceed for a year and a half without them being involved and then seek to re-enter them. What the trial court found was that they knew the entire time their cause of action and that they just chose for procedural reasons and for their own tactical reasons not to allow us to participate as a party, and then sought to come in the back door at the end of the case.
I'm glad you raised that. What is the factual basis of the judge's statement that they knew all along what this potential cause of action was? Because they're saying, we didn't know about this switcheroo with the policy amendment until after we took those depositions and we filed our motion to amend within a month. So there seems to be a chasm between what's being represented to us in the briefs and what the judge said. Can you
I can
bridge that?
I can try. They made all the allegations in the original complaint. The complaints are the 2019 case and the 2018 case. The complaints are almost identical. All those facts were alleged in the original complaint. So we don't have to guess what the plaintiffs knew. They lay it out in their complaint. So that's why I think the judge was able to conclude that they had knowledge of all this stuff back at the time they brought the original complaint.
Including the facts about the misnaming of the insured?
That might be a new fact, but it's not the totality of the circumstances.
No, but that's the fact they're relying on for amending the complaint to include your client, isn't it?
Well, it's one fact, but just because they developed additional facts in the course of discovery doesn't mean that they didn't always have the same causes of action that they asserted in the original complaint and then later on a year and a half later. So that they knew enough to bring a claim. To the extent you don't have to have full knowledge of all the damages and all the potential causes of action. It was enough to know that they knew their role, they knew that they were involved. And this is a 25-year relationship that we're talking about. This isn't something that they found out at the 11th hour that somehow Flagship and Mr. Breton were involved. They were aware of their involvement from day one.
It's the nature of the involvement that I think they say changed.
Oh, well, not really. If you look at the two complaints, there's a few additional facts, but it's the same involvement from the beginning.
All set?
Thank you very much.
Thank you. All right, that concludes our proceedings for today. Many thanks to our court officers, our law clerks and interns, to our IT staff and the clerk's office for making this sitting possible for everyone. Our session is concluded.
Thank you.